Welcome to Care Chat, where we're going to pull back the curtain on senior care and aging and resources and help people demystify all of the different pieces of stuff that they need to know about in order to help either themselves or their parents or a loved one age gracefully and safely. And this episode's sponsor is Right at Home of Chattanooga, of Chattanooga, Cleveland, and Athens. Right at Home provides caregiving services to seniors to keep them safe and independent in their homes. Full disclosure, I am a part owner in that business, so that sponsor was pretty easy to secure this time. Today I'm also your host for Care Chat, and I look forward to speaking with old friends, new friends, people we've worked with, and just provide those resources to the community in a hopefully a different, more casual format than they're used to. So today, my guest is Stephany Pedigo from Chambliss law firm, who does all types of things, but I'm going to let Stephany go into detail what's in her world. So, Stephany, thanks.
All right, Ryan, thanks so much for having me.
For sure.
I've enjoyed very much getting to know you. So what do I do? I'm an attorney at Chambliss. I'm within our estate planning and administration section, and also get to enjoy doing a myriad of other things, including conservatorships and some litigation and what have you.
Nice.
So estate planning is what it sounds like it is, and that's meeting with families and looking at kind of what their needs are, preparing then documents for them that are going to effectuate what they want. So that can be wills or trusts, powers of attorney, what have you. So that's part of my practice. Another part of my practice is kind of the other side of that, where when someone's passed away and it's time to implement those plans, and kind of walk through with a family the probate process and making sure that what their loved one wanted and intended happens. And then the conservatorship process is something that you probably deal with it some in your world.
Oh, yeah. For sure.
Where we have someone who wasn't able to do planning such that they had a power of attorney in place in the event that they were not able to make decisions for themselves.
And that could be physical or cognitive or mental impairment, like something sudden, or they just didn't make a plan early enough, and that's just been a gradual thing, and they end up maybe like getting a dementia diagnosis, like an official diagnosis. At that point, the court kind of sees that they can't make those decisions on their own, correct?
Exactly.
Okay.
Exactly. So if so sitting here today,
yeah.
you and I believe, have capacity to execute documents, and we know
Sure.
what the decisions we're making them intentionally, and there's no problem for us to make those decisions.
Right.
So we could right now sit down, and you have one and I've got one that's a power of attorney, and
Yep.
so we've probably, you as I have appointed our spouses
That's
to
correct.
be
Yeah.
our power of
For
attorney.
sure.
And so in the event that if something happened to me and I wasn't able to make decisions for myself, then my husband can utilize that power of attorney that I already executed, appointing him, and he can then go make decisions that I would need to make. So if I got in a car wreck leaving here today and I wasn't able to, I was in a coma or something.
Sure.
And my husband needed to deal with an entity that I only dealt with. So if I have my own bank account and he needs to be able to access that and talk to those people, he can use the power of attorney where I appointed him, and he can go to that bank and say, I am Stephany's power of attorney, and I need to get this information. And then they should honor that and deal with
Sure.
him that way. So because I appointed him to be my agent when I had capacity to do so. However, if I left here today and I got in a car accident and I hadn't executed any power of attorney, so I hadn't appointed any agent to do anything for me, and then some decision needed to be made for me. For instance, if I were in a car wreck and I'm in a coma, maybe medical decisions need to be made.
Right.
But I haven't officially appointed someone, technically then a conservator would need to be appointed for me.
And that appointment would be made by like a judge, or?
That's correct. So what would happen in that case, like my family would say, we need
we should be the ones to get
we
it,
need
right?
to do this.
Yeah.
And I mean, there's some other this is very general.
Right.
And in practice and in real life, I mean, if there was an emergency and I'm in the hospital, they're going to talk to my husband. That's going to happen.
Right, right.
But if going further on down the road and there's a place where, wow, there's really no one in place officially to be making decisions for me, then my family would hopefully come to Chambliss and get an attorney, and then they would petition the court, and they would just kind of present to the judge, here are the facts.
So like one thing, and we are near these situations, but not super in them from our world, you know. But when we're near these situations, one question that I always kind of think about is like, so let's say it's a medical decision, and someone has to be appointed, how quickly does that stuff happen? Like, because I feel like a medical decision it sounds like a quick decision to me, you know, but
right.
Does the other side, like the judge and the court system,
sounds like a slow. Dichotomy of what you need at the moment. So there is something called an emergency conservatorship.
Okay.
So if we're just stuck and we need help right then, we can we can get to a judge.
There's a means
to do that
okay.
very quickly. And again, you know, in real life, you know, in the hospital, someone's going to deal with my husband. You know, they're not just going to not do that. But we do have ways to get to the court faster.
So I think there's kind of two pathways that I want to kind of go down just based on what you've said so far. One being the reactionary stuff of there's been a major life event, or whether that's in some cases good, in some cases bad, you know, like I win the lottery, that money needs to go somewhere, right? Or something maybe a little less exciting, like, you know, spouse suddenly passes away, or there's a car accident type event. And really it's those documents that have ideally been created that are then executed. Or the other path being the preventative path. And I think that makes the most sense to start. So several years ago, just being in the industry, I kind of alluded to this earlier when we were talking. I had seen so many situations play out that were way more complicated than they seemed to need to be. And so I was a very strong advocate with my wife, and she was all in of like, hey, we gotta not just fill out a will on LegalZoom or whatever online, but we want we have 3 kids. It's just more complicated than here's the keys to the house and the bank account login information. And so, you know, we want to ensure that they are kept good care of if something were to happen to both of us, and not just financially, but who is taking care of them was like our big question because they're young. And so we ended up doing a will and trust, and I think that the trust stuff, while I understand it, I definitely don't pretend to play an attorney on here. So I'm gonna have you describe it, but just kind of talk about what the different preventative mechanisms are. I know wills and trusts aren't the same. There's different types of trusts. There's what do you do with property? And I know there's a lot of detail you could go in, but maybe explain it like I'm 5.
Yes, Sean Spencer.
Yeah, yes. Oh, nice. I love that.
Yeah, so here we go.
Psych is the show, by the way.
That everyone should watch.
Oh my gosh, I'm all in.
I love it. I want to go to Santa Barbara because of it.
Stephany and I are going to hang out after this. I think we're on the same wavelength for sure.
All right, so preventative is always good, like the word sounds. And so what are things that you want to think about? And you've mentioned the really important things. A guardian for your child. So when we've got minor children, there's nothing more important in our life. And when they're adult children, still nothing more important in our life.
Sure.
But while they're minors, then we can do preventative things, like we can have a will in place that specifically says, I'm appointing this person to be the guardian of my children that if this person can't do it, I'm appointing this person to do it. Of course, that's in the event that my spouse has predeceased me. Clearly, if your spouse is living, they're going to be the guardian.
I hope they're still involved. Right.
Yeah. So that's number one preventative thing. Let's make sure that we've thought through that. We've thought about who really makes sense, because sometimes clients come to us and they kind of have a thought of, well, surely that should be my sibling, because that makes sense, right?
Right.
And I don't want to hurt their feelings. No, we don't. But if you also tell me then that sibling has some problems of their own, such that being a caregiver for your child maybe isn't going to be their strong suit, then let's really think through that, and let's put in place someone that makes sense. And then I'm a huge advocate for, let's just go ahead and talk about things with people.
Yeah.
It's better to not surprise people on the back end, and to go ahead and just have the conversations both with the person you'd like to be the caregiver of your children. You don't want that to be a surprise. But then if you think this might be perceived as hurtful to someone else who I didn't appoint, let me have a heartfelt, let's talk.
Right.
And do that as kindly and gently as you can. Do that. So that everyone's just on the same page, and there's not quite, and that also is preventative, in that if there were down the line a need for there to be a guardian for your children, you don't want the sibling who thought they should have been it kind of getting in there crosswise and doing anything, saying, well, maybe you didn't mean for that, or whatever.
Right.
But that it's very clear what you want to happen and why.
I think that those parts of the conversation, when we were building out our wills and all the things, that part of the conversation was definitely the hardest to think through, because it is like, okay, picture that I'm dead. Okay, now that you're there,
right.
What do you want? Like, and it is just really tough, because you're not making the decision for tomorrow, ideally, but you kind of are, and you're also making the decision for hopefully years and years and years and years and years down the road. So when my wife and I were thinking through those things, we kind of had to make the decision for, okay, if this happens within the next 3 to 5 years, there's this answer. And then if it's, let's say, hopefully it's 10 years plus, or 50 years plus, what do those, I hope those answers change. So how easy is it to change, and what's the best way to think about it? Are you thinking somewhat short term? Because again, if you get in a car wreck tomorrow, those are going to be the documents that they're going to go by. So what do you do in that, I guess, is kind of my question. Yeah,
so absolutely, you just have to think short term. You have to think, if these documents were effective as soon as I sign them, are they doing what I want them to do?
Right.
Will what I want to have happen tomorrow happen? So that's our first line of thinking. A lot of times we can build into documents, like if you know, right now I need this, and I am pretty certain that in 5 or 10 years I want something else to happen. Then sometimes we can put that in that initial document. We can kind of have that switch in place.
Okay, so like if-then statements,
exactly.
Kind of like if it's 2030 the year,
right.
then there's this separate set of circumstances. Okay.
Exactly, and so one way that could come into play is maybe a trust that results from the will. We call it a trust under will, and it's also a contingent trust. And so the idea there would be, if my children are minors when this will comes into place, then I want this trust in place for them. And sometimes people think, I don't want this trust to exist for my child's entire lifetime. And so then we could build in, okay, when this child maybe is 25 and they've gone through undergraduate school or something, then a quarter of the trust should be given outright to the child.
Right.
Then at 30, half the trust, and so on. And so there, you can have some future planning in your current plans that way. But to your other question, how easy is it to change things? Quite. It's very easy. And I know the initial process can feel like, my goodness, I had to think of all these
worst case
things.
scenarios.
I didn't like it, and it took a while.
I definitely like pour the drink after going through the emotion of really thinking through that stuff, because it's not comfortable to think about, let alone talk about.
It's really not. It's difficult, and it is an act of love for your family. I mean, it really is.
Sure.
To go ahead and take the time to do it, and the emotional energy to do it, and just to have gone through the process. That is a huge gift that we give to our families. But I'm here to tell you that it's not so bad.
Yeah.
Kind of once you get that groundwork laid, then if you down the road you say, okay, now I think maybe a different caregiver would make sense for my child, a different guardian. I'd like to change that. Not a problem. That's a codicil to your will. That's a one-page document. That's not hard. We can do that without undoing everything else that you've done. So,
I think the word intentional keeps coming to mind when I think preventative. I think intentional. I've always had this like idea in my head that I would be able to provide my kids with, financial stability and a stable home. Sometimes that's not a reality. So I think I'm very lucky. I grew up both my parents, and we didn't have split household type things to deal with. But it's super difficult when you didn't have good examples growing up of exactly what it means to provide either a stable home or stable finances or whatever for your own kids. So I think it's important for people to think like, hey, just because I didn't have a great example of this, there's tons of resources to help me execute that for my kids, whether it's and I think another big maybe misconception is you have to be like, okay, there's no use in doing this until I have $10 million or whatever. Like you could have a 800 square foot house and a vehicle, and there's still like decisions have to be made if you pass away, or if your kids are left without you as a parent, and so there's no real reason not to do this. And I think that needs to be that intentionality of providing, like, okay, it's kind of like I've made these really logical decisions for a time that is going to be very illogical and hard for people to understand, and it almost is kind of your legacy in the sense of like, I've helped make these really great decisions that are going to at least nudge people on the right path after I'm gone, or maybe even before I'm gone, depending on like dementia or any other kind of things that may pop up. So I think that's really important. It was important for me to learn that of, hey, there's not really like too early to deal with this. And I think it's really interesting, learning through. So my great aunt passed away. She had put everything in an irrevocable trust, and skipping probate was like the big hot topic when she passed away. It was like this is like colossal amounts of work that don't have to happen because she did things the way she did it. And could you maybe explain it like I'm 5, the reasons that one type of document or trust or will would make sense versus another? Is that
absolutely? That's fair.
Okay.
So yes, a lot of people have kind of as a motivating factor to doing planning of, I've heard probate's horrible, I want to avoid it. Let's do that. That's true and false. Probate can be a huge pain, and it can go on forever, and it can get expensive, and that can be true. It can also be true that it's not so bad.
Okay.
And it's okay. But if our motivating factor is I just don't want to open that door. I'd rather not do that. Then here's how it works. When someone passes away, we look at, do they have a probate estate? Like what part of their estate is probate? What part is non-probate? So anything that a person owns in their name alone when they pass away is part of their probate estate. And then we need to go to the judge, and we need to have an executor appointed to officially have authority to distribute what's in that person's name alone that's in their probate estate.
So for example, that could be like, here's a checking account that is in my name.
Right.
Or maybe bought a vehicle in my name, but I never moved it anywhere else. I bought it under my own name. But are those like
yes,
examples, I guess?
Those are both examples. Both of those actually sometimes can have some quick fixes that we can help families with. Actually, I just helped a family, I think, just kind of skip probate and get through some other. So we can transfer vehicles some pretty easily. Don't have to kind of go to the whole thing. A lot of times, checking accounts have a pay on death beneficiary on them. So and so here's the other part of my story.
Yeah.
So if you own something in your name alone and there's no beneficiary designation on it, that's your probate estate. And so that's where we're like, we're going to have to get somebody in there that's got authority to move these things to where they're supposed to go. And then in the other camp is your non-probate estate. So anything, if you have a trust in place like your great aunt did, and importantly, the trust is funded. So we've actually titled property to the trust, and the trust officially holds it, then that is in your non-probate estate. Court doesn't need to do anything with that at all, because that property is going to pass as per the terms of the trust.
Right.
The trustee has the authority to do that. We don't have to get any additional authority for the trustee to be able to distribute the property the way the trust said it was supposed to.
Right.
So that's kind of the difference. Is like, why does someone have authority to deal with the property? The trustee has authority to deal with the property in the trust. With a probate estate, until the courts meets with the executor and appoints them officially to be the executor or personal representative of the estate, then no one officially has authority to deal with the property that's in the probate estate.
Okay.
If that makes sense.
It does, yeah.
And so over here in the non-probate estate would be property held in trust. It would also be property with a beneficiary designation on it. So our 401ks and our IRAs, when we list a beneficiary on those accounts, then we're golden, because they're going to go straight to that beneficiary.
So what if an account has a beneficiary named, but it's also included in the trust? So
that's a great question.
Which one takes precedence?
The beneficiary designation.
Okay.
And that is something. I just met with someone yesterday and kind of went through this with them. They really own their assets. She was a retired nun, and she was amazing, and I loved her, and she was 92 and absolutely brilliant and perfect, and
that's great,
fabulous. And on us, all of her assets are held in 2 accounts with beneficiary designations, and that's all she has. Like that's it. There's just these 2 accounts. And the reason she wanted to meet with me was to tell me, I want to make sure that my great niece gets a certain sum of money. I was like, and so I want to add that to my will. And she kind of thought, that's all we need to do. We just add this to my will, please. And I could have just said, sure, let's do that. But I wouldn't have been doing her any favors.
Because it could still because the beneficiary still gets the account upon death.
Right. And the great niece was not the beneficiary on those accounts.
Because the beneficiary takes precedence over will or trust.
Exactly.
Interesting.
Exactly. So I
don't think that I mean,
most people don't understand that. It's not because you think, I mean, we just kind of grow up hearing about wills, and you think, well, if your will says it,
right.
Clearly that's what's going to happen.
There's this Post-it note I carry around in my wallet. It says where it goes, right?
Right.
Yeah.
And it's just that it is true. That's true for the probate property. So for this nun, she didn't have any probate property. She only had non-probate property, and her will only affects the probate property. So my counsel to her was, let's get done what you want to get done, and the way we can do that is we can just adjust your beneficiary designation.
Yeah.
And then that's going to do what you want that way.
Okay. So my wife and I did a trust as well, and so we moved all of our property and assets and accounts and all of those things are in that trust now. And I was very apprehensive for the simple fact of this sounds super overwhelming to like deal with all this paperwork. And it was like, I mean, we're going to have to go down to a deeds office and pull those and get it and re-sign and move the house stuff. And there just seemed extremely overwhelming. I will say the attorney that we worked with basically had like a list all of your stuff, and I have this letter that I'm going to send to all these people, and I need you to show up at this one place, and we're going to sign all this stuff. Like, I mean, they made it very approachable. It was still a lot of, I started getting like our from just retirement accounts, I would get this change has been made letter. Then it would be another change has been made, and do you approve the change letter? And then it was like, okay, here's an account balance from your old thing, and now here's the account balance from the new thing and this new name. And I mean, it was a ton of mail. But really beyond that, it was not nearly as bad as I thought it would be. I'm sure, like, probably because our situation isn't as complicated as some people's is or involved. But I think for anyone that has in the back of their mind, they know they should do something. And I know that was a big excuse for me not doing it any earlier than I did. But eventually, we just kind of bit the bullet, did it, and it really was not that bad. So I would encourage everyone to just get it over with, because kind of like you said, if we have a change, it's super easy to do at this point. Nothing overly complicated. So is there one thing that you would recommend across the board that people need to say, like, you really, like, this is the gold standard, this will make your life and everyone else's life around you way easier? Or everyone's situation is different, so I'm sure it's it depends type answer. But if someone has a will, should they look at a trust, or and vice versa? I don't know the best way to ask that question, but I think you probably know where I'm going with it.
Yeah, I think so. And so, yeah, the beginning of my answer would be it is going to vary with individuals. Sure. Probably you have in place both a trust and a will. So there's something that is called a pour over will, which basically is kind of like it's cleanup. If there's anything that didn't happen to be funded to that trust, then your executor is going to have the ability to get it and pour it over there,
right,
to your trust. And it sounds like you've done a great job. Congratulations. Really well done, because that's the trick. And that's the trick. If you have clients who really are motivated to see the whole thing through, then a trust, I think, I might say that's the gold standard, because it is going to carry you through all. In the event there was incapacity at any point, the trust is going to cover that for you, because your spouse is a co-trustee with you.
Right.
So it's very easy for your spouse to be able to handle all of the things that are held in that trust in the event there's any incapacity issue there.
And would kind of the way to think about that be like, okay, well, here's this, in our case, husband and wife, there's kind of this third entity that you both are tied to the trust, right? And if one person goes away, even anything that they had is still within the trust, so the spouse has access to everything super easily, because it's almost like this third spouse, I guess. I don't know how to say that, but like it's almost like this
don't
third.
say that.
Yeah, that wouldn't work.
Don't say that.
Yeah, we can cut that out.
No.
But it's this like oh, I think of it like a business entity.
Yeah.
But that's because that's how my mind works, right? It's like we both own this thing together. If one goes away, the thing still exists.
That's exactly.
And I guess that's kind of what I mean. I don't know. Yeah.
Yes.
That's okay.
No, you're good. You're good. Yes, the trust is an entity. That's exactly, precisely what it is. And so yes, you both have authority over this entity. You're both a co-trustee over it. And your documents are probably drafted such that, like I was kind of saying, in the event that one of us can't act as a co-trustee, it's okay. The other one of us can act as the sole trustee. And then the way that this is then an estate planning document is probably your documents are drafted that once the second spouse has passed away, then here is the successor trustee.
Right. Exactly.
Yeah, and eventually, and this might be a place where you'd plan further on down the road. Like right now, that's probably not one of your little children. No. It shouldn't be.
Not yet.
But one day, it probably will be.
Sure.
And so then one day, you might want to come in and say, here's an amendment to our trust. Now, my son will be our trustee. And then that way, the successor trustee is who will then carry out the terms of the trust, which probably is to then divide into thirds our assets to each child. So that's kind of how that would work. So if I have a client that comes in like you, and you're dedicated to, I really do want to fund this thing. I want it to actually be an entity. I want it to do what it's supposed to do. Great, let's do that. If you have a client that's like, I don't really, I don't care.
Yeah.
And just getting here is hard enough, and I feel overwhelmed, really.
Right.
And that I'm probably not going to follow through. Then let's not start. Let's not have a trust, because it's not going to do you any good if it's not funded.
If it's not funded, right. And by funded, you mean moving assets of any real type, as like changing ownership of those assets from me as an individual to the trust as an entity.
Precisely.
When you say fund. Okay.
Exactly.
I know we are running a little bit short on time, so I want to do maybe we table so we talked a lot about the prevention part. Maybe we do another get together on the reactionary part. What happens if it actually, okay, so now what? Mom or dad has passed away. They don't have this in place. What happens? Mom and dad has passed away. These are in place. What happens? So that'd be a cool thing to talk about next time.
I would so love to.
Sweet. So, Stephany, if somebody listening or watching wants to get in touch with you or Chambliss because they have questions and maybe want to get the process started, or at least see if they want to get the process started, is there a good place for them to go? Maybe the website, or reach out to you directly? Do you mind just sharing what the best way for someone to get in touch with you guys is?
Absolutely. So we do have a web presence, and Google Chambliss Law Firm and you will find us. Our full name is Chambliss, Bahner and Stophel.
Right.
So that's probably the easiest way. And then our phone number, I think, is 423-756-3000.
That sounds right.
And then you can find us that way.
All right, perfect.
All right.
Awesome. Well, thank you so much for coming on, Stephany. This has been great.
My great pleasure.
Yeah.
Thanks, Ryan.